the top 3 things that you must do if you want to drop domestic violence charges. Let's go. My name is Veronica. I am a criminal defense attorney here in Los Angeles, and I help people who have been arrested put their criminal cases behind them so that they can enjoy their lives and their freedom. And in this video, we're going to be talking about the 3 things that you must do if you want to drop domestic violence charges that you have against someone else. So first, before we begin, in California, you're not, once the police are called, once the other person is arrested and they are taken to jail or they're given a citation, you're not in charge anymore. You're not the boss of that case. You cannot just call up the judge, you cannot just call up the prosecutor, the police, and say, hey, I don't want to press charges, I want to drop them. I know they say a lot of stuff like that in the movies, on TV shows, and when I see that, I love lawyer shows. I love, well, kind of hate watch police shows sometimes, but that's the one thing that really actually drives me crazy, that they make it seem like the alleged victim is in control. So if you're watching this video, you're doing your own research and you probably know you cannot just drop those charges. But there are 3 big things that you can do and you should do if you want to try to help the charges be dropped. Number 1 is you want to get a copy of the police report. In the state of California, you have a right to a copy of the police report. So if the first court date has not happened yet, you can go to the police station, your local police station, wherever the arrest was made, that agency, go there and you can actually fill out a form and get a copy of the police report. And the reason why that's important is that many times the cops will write down what they say you said, but it's not accurate. In fact, almost never. It would be hard for it to be completely accurate because, I mean, how many of these incidents are they going to one after the other, right? How long is it before they actually write this report and they have to try to remember what you said? How many domestic violence calls did they get that night, right? And maybe they're rushing paperwork. It really can stack up for them. So you can imagine that even if they're trying to be totally honest and do everything completely right, whatever's in there probably is not totally accurate. And that's giving them the benefit of the doubt. I will also say that in my experience, if the cops make an arrest, when they write the police report, they want to justify the arrest, right? They don't want to write down, yeah, we came out, we heard them arguing, there was no visible injury, they both said that it was only a verbal argument, so we decided to arrest one of them. Of course, they're not going to write that, right? So if they decided just based on a hunch, based on whatever, they just jumped to a conclusion and made an arrest, they're going to try to justify it in the report. So get a copy of the police report. If charges have already been filed, there's already a court case open, ask the prosecutor. The prosecutor they actually have a victim advocate that should be assigned to your case. Now, if you don't want to move the case forward, I wouldn't talk to that person and tell them, your side of things. Don't make statements to them probably. But what you can do is ask for a copy of the police report and you have a right to it. The second thing is, if a court case has already been opened and there is a defense attorney, especially a private defense attorney that, you can call or text and they pick up the phone and talk to you, they should be requesting copies of any body-worn video or audio or video recordings of you. So let's say you look at the police report, you read it, and you're like, I didn't say that. They got it completely wrong. Okay. So there should be some kind of, and there usually is, most of the time, there's going to be either body-worn video, there's some kind of video or audio recording of you. And so you want to tell the defense attorney, hey, that's not what I said. And then it's up to them to request that body-worn video, get copies of it, and then take a look and, hopefully start talking to the prosecution and the judge saying, hey, look, the police report says this, but if you look at the video, this is what the alleged victim actually said. Now, that's only if what you said at the time is good for the defense. So if you're in contact with the defense attorney, you don't want to tell them to request the body-worn video if it's not good for the defendant. But the prosecution eventually will get it anyway. It's just that usually they will not get it until closer to trial. In these types of cases, and if they're not requested. Number 3 is that you want to consult your own lawyer. So as a as a defense attorney, there's nothing wrong with us talking to the alleged victims in these cases. It's not unethical. There's nothing prohibiting us from doing it in general. There's no general rule stopping us from that. But what we can't do is give you legal advice because there's a conflict of interest. So let's say you get a subpoena and you want to know, well, do I actually have to come to court? I don't necessarily want to testify. What are my rights? Maybe they just left it at your door, but they didn't hand it to anyone. Was that proper service? Can the subpoena be quashed? What can happen to you if you disobey it? All of these questions are questions that cannot be answered by the public defender or by a private criminal defense attorney who is representing the defendant because we have this conflict of interest. So my recommendation is to, get some free consultations and maybe pay a lawyer a little bit to just advise you on your rights because that lawyer will not have a conflict of interest. Anyway, I hope that this helped. If you do have a criminal case or somebody you love has a criminal case in Southern California, please feel free to give me a call. You can also book a consultation just down below.